Hi, my name is Christina Tegolo. I work for Settled. I would like to give you, first of all, a welcome. I would like to just say a few words about this event, this session. First of all, a big thank you and a special thank you to Katie Roxburgh, who has helped us organizing this event, and to Islington Council to contact Settle and asking us to inform you and to give you some information on the EU settlement scheme and the application for pre-settle status and settle status. This event is organized by Settle. Settle is a charity that was created in 2019 to help EU citizens to live in the UK after Brexit. When we talk about EU citizens, in reality, we talk about a big group of people. It's not just EU, but it's also EEA, and also people from Switzerland, and also their non-EEA family members. During this event, this session will be 2 hours long, you will have 2 speakers. The first presentation will be presented by Chris Desira, who is the director of Seraphos, an immigration law practice based in London. And Chris is also a lawyer that works with the EU delegation for the EU in the UK. The second part will be done by my colleague, presented by my colleague, Maria Lurente, who is our volunteer manager, the Settle volunteer manager. Both sessions will have a PowerPoint and a Q&A at the end. I don't really want to keep you long, but I'll say a couple of things. Keep your microphone muted, please, during the session. Please, if you have any question, use the chat, and during the presentation of Chris, Maria and I will try to answer to some of your questions, but Chris will be able to answer to the most complex questions at the end of his presentation. I think we can just start. So if Chris would like to share his PowerPoint slides.
There we go. Let's try this. Can everyone see this?
Yes.
And can we see it better now?
Better, yes. Thank you.
Okay. Thank you, Christina. Thanks for the lovely introduction. I'm going to skip an introduction from me and just get straight into these slides because we've got quite a lot of information to talk through in the time that we have. I'm happy to have these slides made available afterwards. So if anyone wants them, they can be emailed to you, so you don't have to take lots of copious notes as I talk. So let's get right to it. The reason why we need to apply to a scheme called the EU settlement scheme is because EU free movement law ends at the end of this year as a result of Brexit, which means essentially we need to swap our lawful residence rights under EU law with lawful residence rights issued under UK immigration law. So it means we basically have to apply to this EU settlement scheme process in order to get one of 2 immigration statuses. The first immigration status a person can be granted is settled status. It's only granted to those who have been living in the UK continuously for a 5-year period. And the second immigration status a person could get is called pre-settled status, which is a temporary residence permit granted for a 5-year period, which permits people to live in the UK lawfully for up to 5 years, at which point they can then reapply to the EU settlement scheme for settled status. And then once you achieve settled status, you're free from immigration control, you're permanently resident in the UK, and it's fairly easy to attain settled status. So you're protected for the duration of time that you want to continue living in the UK. There are 2 key deadlines to this scheme. One of them is called we call a residence deadline, and then the other one is the application deadline. The residence deadline is the end of this year, 11 p.m. on the 31st of December 2020. This is the key date for European citizens to commence their residence in the UK if they haven't already done so. And once they commence their residence in the UK before the end of this year, then that permits family members to join them at any time in the future. The second deadline is the 30th of June 2021. That's the ultimate deadline to apply for pre-settled or settled status, the first status that you will be granted under the scheme. So your application must be submitted before this date in order to potentially protect your lawful residence after this date. So it's a really important deadline, the application deadline. So almost all EU, EEA and Swiss citizens can apply to this scheme. We say almost all because there may be some people who don't necessarily have to apply, but they have a choice whether to apply or not. First of all, those that have to apply are people who don't already have an immigration status under UK law. And that's not to be confused with a document called a permanent residence document. So some long-term residents may already have been issued, if they apply for this, a permanent residence document, which looks like a visa on a blue card that can fold into three. This permanent residence document, this blue card, is issued under EU law. And because it's issued under EU law, it no longer will be valid in the future. So you have to swap this permanent residence document for settled status under the EU settlement scheme. People may have an immigration status under UK law called indefinite leave to remain, or something similar along those terms. It could say indefinite leave to enter. It could just say indefinite. If you've got a letter or a stamp in an old passport that says indefinite on it somewhere, then you may already have immigration status called indefinite leave, at which point you have a choice whether to apply to the scheme or not. And I'll touch on why you might choose to do so a bit later. Anyone who's British, dual British or multiple citizenships with one of them that includes British citizenship, then you can't apply to the scheme. Your British citizenship is your protection, and it prevents you from being granted an immigration status. Irish citizens don't have a choice whether to apply or not. And all family members, regardless of their nationality, need to apply unless they're already British or unless they already have a permanent immigration status. Now, I touched on that residence deadline. So EU citizens need to enter the UK and commence their residence before the end of this year to be eligible for pre-settled or settled status. But some family members don't need to be here by the end of this year, as long as the EU citizen is. And that's the family members that are on that list. So it's spouse or civil partner. Durable partner. Durable partner is basically someone who's not in a marriage or civil partnership, but they're in a long and serious relationship, and they can demonstrate it's a long and serious relationship. And anyone in the ascending and descending lines of the EU citizen or the spouse or the civil partner of the EU citizen, they don't need to be here by the end of this year, so long as the EU citizen is and will be eligible under the EU settlement scheme. And so they can join the EU citizen at any time in the future. They just need to make sure that the relationship begins before the end of this year and continues to exist at the time they want to join the EU citizen later. Now, touching on this application process itself, I'm not going to go into a huge amount of detail because I appreciate there may be many people on the call who already gone through the system and have pre-settled or settled status already. But I'll touch on briefly about the process, and then we could touch on some more important aspects that certain citizens need to watch out for. So the three key issues that you need to satisfy in this application process is to confirm your identity and nationality, and if you're a family member, confirm your family relationship to the EU citizen. You need to confirm your length of residence in the UK, because that dictates whether you have pre-settled or settled status. And then you have to undergo a criminality check, so basically answering a few questions about criminal history if you have any. The application process is mostly online, but there is a paper application available for certain people and certain categories of citizens, where the online application won't be able to deal with that complex scenarios that they may have. But if you can engage with the online process and you're a person that can fill in and submit an online application form, then the best thing is to engage with the online process, because you're likely to get your status quicker, and it will be a more streamlined system than having to engage with a paper application process. Now, I'm going to touch on the residence, that second key point in proving your application process to get pre-settled or settled status. And I'm going to continue talking about residence quite a few times during this presentation, because continuous residence is quite a crucial part of this whole process. And it's going to continue being a crucial part of this process for those who are granted pre-settled status. Now, in order to get settled status, which is the ultimate aim for everyone, you need to have been resident in the UK continuously for a 5-year period. This does have a legal definition. It means that you need to be resident in the UK for 6 months or more in every 12-month period of that 5 years residence you're relying on, in order to demonstrate you have that 5 years continuous residence, and therefore you should be granted settled status. Now, you choose the 5-year residence period. It doesn't have to be the most 5 years. If you've been living in the UK for 20 years, then you've got a 20-year window at which you can choose that 5-year period. And when you choose that 5-year period, you divide that 5-year period into 12-month blocks. And within each of those 12-month blocks, you count the number of days you've been outside of the UK. And that's whole days. You don't count the day you leave, you don't count the day you return. If at any point in any of those 12-month segments, you've got more than 6 months absence, then you're going to have to look at a different 5-year period if you've been a long-term resident, and you can look at different 5-year periods. If you do have a gap now and you haven't been resident for a long time and you don't have other 5-year periods to look at, then I'll explain what you might need to do if you've got such a gap and that gap exists this year. Within that 5-year period, you're allowed one and only one absence of more than 6 months, but less than 12 months, and it has to be for an important reason. The important reasons are listed there. It also includes, as the Home Office have said to us verbally, but not yet in writing, it includes absences due to COVID-19, due to the pandemic. So they've said that enforced absences due to the pandemic will be an important reason, at which point you're permitted one long absence for that important reason of between 6 and 12 months, but only one in your 5-year period. Compulsory military service, if you're from an EU country that still requires this, then any period of absence is permitted, because it's compulsory military service and you've got no choice but to adhere to that. And this isn't going to be the first time I touch on continuous residence. I'm going to bring it up a few times, so hold off fast on any questions for the moment on this. Residence start dates, which I touched on earlier, the 31st of December 2020 at 11 p.m. more specifically is the cutoff date. So it's important that you start your residence in the UK. Now, we have had a lot of questions from people who are studying remotely or working remotely, but they've yet to move to the UK. Now, working or studying for a UK-based organisation is not enough to bring yourselves within the EU settlement scheme. You have to actually be physically present in the UK to be eligible for pre-settled or settled status. So if you haven't already previously resided in the UK and you're living outside of the UK, well, you need to move to the UK before 11 p.m. on the 31st of December 2020 if you want to be part of the EU settlement scheme. If you don't, it means you can't be part of the EU settlement scheme. And that means if you intend to move to the UK for the first time next year, then you're going to be doing so under different visa requirements. So if you're a student, you have to apply for a student visa. If you're working, you have to apply for a work visa. And any one of those visas have multiple criteria to meet, and you may or may not meet them. And they're a much more complex and costly process. So the EU settlement scheme is the easiest immigration process you have. And if you want to be within the EU settlement scheme, you have to be here before the end of this year. So how do you prove, once you're here in the UK and you're resident, how do you prove your residence in the UK? Well, the online form will try and do this for you if you've already got government records at DWP and HMRC, the two departments that deal with work and self-employment and benefits and social assistance. If you've engaged with either of those, then they may have records of your existence. And if they do, the online form will be able to check those records and possibly verify your presence in the UK. If it can't, then you're going to have to provide evidence yourself, and the online form will tell you where you need to do that. And if you need to provide evidence yourself, well, then you can provide quite a varied choice of documents then to prove your presence in the UK. You know, for example, if you're newly arrived, so you're arriving in December, you chances are you have very little paperwork to demonstrate that you're residing in the UK. So in this scenario, the Home Office will accept boarding cards, flight bookings, evidence that you've travelled into the UK, and that should be enough to grant you pre-settle status. If you've lived in the UK for 5 years and you're applying for settled status, and you need to provide evidence, well, you can choose anything with your name and address but there are a couple of rules to presenting documents. They need to look like you're living in the UK. So, for example, if you provide a bank statement that has no transactions, the Home Office are likely.
Hi, Tracy. Can you hear me?
Sorry, the Home Office are likely.
No, I'm just
information for you because the bank statement doesn't have any transactions and it doesn't look like you're engaging and living in the UK. But if your bank statement has many transactions on it, then they'll accept that as presence in the UK. Also, the documents will provide proof of residence, proof of presence based on the date that it's issued. So, for example, a monthly bank statement will prove that month, an annual bank statement will prove the whole annual period. But apart from those rules, you can provide anything to prove your presence in the UK. So it's a fairly flexible application process as long as you've got that paperwork and it exists. Now I'm going to touch on some groups and I'm going to talk about these groups specifically because they have unique characteristics and they answer a lot of questions that most of you may have about this process. So for students, as I touched on before, they need to be present in the UK before the end of this year. We speak to loads of students who have started courses this autumn but have yet to move to the UK because they're studying courses remotely. Well, they need to move to the UK before the end of this year to be eligible for pre-settled status. Students also don't need to hold comprehensive sickness health insurance to be granted pre-settled or settled status. This scheme is about residence in the UK. It's not about what you're doing in the UK. What you're doing in the UK only proves your residence. So it doesn't matter that you're working, you're receiving benefits, that you don't have comprehensive sickness health insurance coverage. None of that matters for the EU settlement scheme. So students or anyone who's self-sufficient doesn't need health insurance to apply for and be granted pre-settled or settled status. I've touched on this before. I'm going to keep touching on this because it's important. If you're remote working, move to the UK before the end of this year. This avoids having to engage with student visas, which are costly. You can see some of the prices there. And there's no guarantee that under any other visa scheme, you'll be able to achieve settled status under those types of schemes. The EU settlement scheme, as long as you meet a few basic requirements, then you're almost guaranteed to get settled status at the end of it. Now, children have a bit more of a unique position and depending on where they were born and who they were born to. Now, for children, like many citizens, if your child is Irish or British, then they don't have to apply. British, you can't apply. If you're Irish, you have a choice to apply. You can, if you want, to apply for pre-settled or settled status. You don't need to apply if your child already holds indefinite leave to remain or enter. Again, that applies to any citizen of any age. And so, you know, you've got citizens who have a permanent residence in the UK or have indefinite leave to remain in the UK. For those children who are not born British, they might have a choice to register. But if they're not born British and they don't register as British, then those children must apply to the EU settlement scheme before the deadline. and if they don't, then they will be considered unlawfully resident. But for children, they may not know that they're unlawfully resident until very far in the future, when they start engaging with more adult services and university degrees, and then start applying for the first jobs, at which point they suddenly realize at that stage that they're unlawfully resident. So it's really important that you figure out whether your child is born British, or if they're not, you might choose to register them. But if you don't choose to register them, then you must apply for pre-settled or settled status for your child. If you're applying at the same time as your child, where you're granted pre-settled status, then your child is granted pre-settled status at the same time as you. They get the status that you're granted, and at which point it doesn't matter how long the child has been physically present in the UK. But if only your child applies and you're not applying, maybe because you can't, because you're British, then your child needs to prove their length of residence in the UK to get settled status. So rough rule of thumb for children: by the 30th of June 2021, you need to make sure your child is in any one of those categories. So confirm that your child is born British, and get that in some physical evidence of that, for example, by applying for a British passport. Confirm that your child has been registered as British, or register your child as British. Or confirm that your child is Irish or holds indefinite leave to remain in the UK, at which point they don't need to apply, they have a choice to apply. But if neither of those first three options apply to your children, then they have to apply for pre-settled or settled status by the 30th of June 2021. Now, for the older citizens and family members amongst us, let's talk about some of the issues that may come up here. So for older residents, they may have been here for a very long time. And one important thing to stress here is that long-term residence in the UK is not a protection from unlawful residence. It doesn't guarantee that you don't need to engage with a scheme. It doesn't mean that you're protected from any unlawful residence in the future. It doesn't matter how long you've lived in the UK. You could have lived in the UK for 60 years. If you don't already have a UK immigration status, then you need to apply for settled status. I know some long-term residents that I've spoken to are reluctant to engage with a scheme because they've lived here their whole life and they consider the UK their only home. But unless you already hold a UK immigration status that says indefinite on it somewhere, then you have to apply for settled status, whether you're reluctant or not, or whether you're really unhappy with engaging with this. You really must apply for settled status in order to protect your residence going forward, in order to protect your rights to accessing pensions, health insurance, and so on. So it's really important to apply. Some of you may have that indefinite leave to remain status. So if you've been here a long time and you know you've got something from the Home Office that may have looked like they've given you an immigration status in the past, well, you need to check to make sure that that's still valid and you can still rely on it if you don't want to apply to the settlement scheme. So you need to have a look at your old passports to see if there's a stamp on it. You need to look to see whether you've been given any old letters. It has to contain the word indefinite. There's lots of varied immigration statuses, but if they all have to have the word indefinite in it for you to be protected. And if it doesn't, you have to apply for settled status. It also needs to be valid. So if you've got an old letter granted 30 years ago to you, well, it still needs to be valid, which means if you've left the UK for more than 2 continuous years at some point in the past, then it's likely that that indefinite leave to remain or indefinite leave to enter is no longer valid. It's expired, and it expires after 2 years absence from the UK. If that's occurred in the past and you know you've been absent for more than 2 years after you were granted that indefinite status, then you need to apply to the settlement scheme because that indefinite status is no longer valid. But even those who have a valid indefinite leave to remain status, we still recommend you to apply for settled status if you're inclined to do so, because there are chances are the Home Office have no records of that immigration status on their own records. If you lose your old passport or you lose your old letter, well, there'll be no evidence at all that you had indefinite leave to remain in the past and that you're not unlawfully resident in the UK. As soon as that document disappears, there'll be nothing to prove this. So if you want to, you should apply for settled status. This enables you to reconnect to the Home Office. The Home Office will recreate records for you. They'll know that you're lawfully resident in the UK now and also in the future with the settled status. You'll have that digital status, at which point you no longer need to rely on that old paperwork. So if you ever lose that old paperwork, then it's not so serious because you have the new digital status. So you've got a choice to apply, but we do recommend you doing so. This process is mainly digital, but not everyone is digitally skilled. Not everyone can fill in an online form and engage with a digital process. Not everyone has email addresses or telephone mobile numbers, which you need to be able to log in and access your application and your status later on. So if you're not digitally skilled, you can still apply to the scheme, but you're going to need to obtain a paper application form to do so, which means you need to contact the Home Office Settlement Resolution Centre, which is a call centre that specialises just in the EU settlement scheme, to request a paper form from them. And if you want that, they'll send it to your home address, at which point you can complete it and send it back with your ID document and any other evidence which you need to provide. And then the Home Office will confirm your immigration status once they receive this. So there are other routes if you're not digitally skilled, but if that's too much of an obstacle for you, then you can engage with organisations that can help you through this process if you need that help. And Settled is one of the key organisations that are out there helping people with this. Their team are experts on this process, and they're there to help anyone who sees hurdles in front of them with engaging with that system. So if the paper application process sounds quite arduous for you, and in fairness, it can be a little bit, then contact Settled and they can help you through the process. Some longer term residents and to be fair, some new arrivals as well may no longer have a valid national passport or national ID card. And the process requires a valid national passport or national ID card to apply to it. Some people have realised that their documents have expired, particularly as they never needed to renew it, and they've never been outside of the UK, or they've just not been outside of the UK for a number of years, and their passport or national ID cards have subsequently expired. Well, you need to renew it. But if you can't renew it because maybe you can't travel to an embassy or consulate, or you can't travel back home to your home country to renew it, or maybe you don't have the money to be able to afford to renew it, well, you can rely on expired documents. The Home Office will accept expired documents as evidence of identity and nationality, but only if you explain why you're relying on an expired passport. And you have to have a valid explanation of why you're relying on an expired passport. You can't rely on an expired passport, for example, because you simply can't be bothered to renew your passport. The Home Office are probably going to say to you, you need to renew it in this instance. But if you're too ill or infirm to be able to travel to London or maybe to your home country to renew it, well, that's a valid reason. Then apply to the EU settlement scheme, use your expired document, tell them in your application, I'm too ill to renew it, give them evidence of that illness, and they'll rely on the expired document. Now, let's talk about the immigration status itself, because there are a few things you need to be aware of about it and how to engage with it, and when you need to show it to third parties. So for EU citizens, you're granted a digital status. And this digital status means you're not going to have a residence card or a visa given to you. You're not going to have something tangible in your hands to hold and to take out of your wallet or your purse or your bag to show someone. You're going to have to engage with a digital platform to be able to view your status and share it with third parties. There are inherent issues with just a digital only status, and you know, everyone is continuing to lobby the government to change that digital only form of status, and Settled is doing a lot of work behind the scenes to try and do that. But for now, we need to engage with the digital status. And for EU citizens, that means you're going to need to log into the .gov.uk website, and you're going to need to manage your own status, which means if your contact details change or your identity document details change, you're going to need to log into your digital status, update the details on that status, and ensure that it continues to be updated. If you need to share it to third parties, you're going to need to log into your digital status, click the sharing options, and then share it with the person that's asking to see this status. However, it's important to stress here, and I'll stress it again a bit later, that between now and the 30th of June 2021, no one is lawfully permitted to ask to see your pre-settled or settled status. No one is lawfully permitted to restrict any rights, any services, any support or any opportunities to you if you refuse to share your digital status or you don't yet have your digital status. This is because up to the 30th of June 2021, you can continue to rely on your EU passport or your EU national ID card as evidence that you're allowed to be in the UK, that you're allowed to be employed, that you're allowed to sign contracts, that you're allowed to apply for benefits, that you're allowed to access healthcare, and so on and so on. So if anyone does ask for it, reminds them that they can rely on just your passport and national ID cards. But also, you know, we have to, and if they're asking for it and they're insisting on it, it's a good idea to report these instances where they occur, so we can try and tell the UK government that this digital process is not working and people don't understand it and are not engaging with it lawfully. So up until the 30th of June, your passport and national ID card remains the document to rely on. But by the 30th of June 2020, you need to make sure your digital status is up to date, because from the 1st of July, everyone will start asking for your pre-settled and settled status. Every time you do something, you want to access something, you want to sign something, they're going to say, well, can I see your ID and can I see evidence that you're lawfully allowed to be in the UK? If you don't have your status by the 1st of July next year, then it's okay, as long as you've made your application before that date. And so if someone asks to see your digital status, you can say, I don't have it, I've made an application, and they can check with the Home Office to confirm that you have made an application and they're permitted to offer you the job that they're offering you. So let's talk about the two statuses and the differences between the two. Pre-settled status is limited status. It expires after 5 years. It will have an expiration date on it, which means you need to make sure you apply again to the EU settlement scheme to request settled status before the expiration date passes. Because if you apply after the expiration date of your pre-settled status, you will be unlawfully resident in the UK. While you're holding pre-settled status, you have to maintain your continuous residence in the UK. This goes back to the rules I talked about earlier about residence. You need to make sure you're in the UK for more than 6 months in every 12-month period of your residence in the UK, and certainly during the period where you have pre-settled status. If you break your continuous residence, so for example, if you have pre-settled status and then you leave the UK and you're outside of the UK for 8 months and you don't have any important reason why you're outside of the UK for those 8 months, then you've broken your continuous residence. This means currently, as the rules are, you will be refused settled status. You won't be issued a second 5-year pre-settled status grant. You will simply be refused any immigration status under the EU settlement scheme. At which point you're going to have to hire a lawyer at great expense to look at your life in the UK, to see if you're going to apply for any other types of visa in the immigration system. You'll have to be able to afford those other types of visas in the immigration system. You'll be starting your route to settlement again from fresh if you can get a visa in a different immigration system. And if you can't get a visa within the immigration system under any other types of routes other than the EU settlement scheme, well, then you'll be required to leave the UK at that point. So it's really important that you apply for pre-settled status, and once you get pre-settled status, you maintain your continuous residence in the UK. Break it, you're going to have a lot of trouble in the future, and maybe a lawyer, however skilled and expensive they are, may not be able to help you. So make sure you apply for pre-settled status, make sure you get it, make sure you maintain your continuous residence, make sure you apply for settled status before your pre-settled status expires. You don't have to wait until your pre-settled status expires to apply for settled status. You can apply any time once you've reached 5 years continuous residence in the UK. So, for example, if you've been in the UK for 2 years before you get pre-settled status, which is a 5-year residence permit, you can wait until 3 years into your pre-settled status residence permit, because at that point you've been here in the UK for 5 years, at which point you can apply for settled status. You don't have to wait until the pre-settled status has been used up and apply before it expires. You can apply as soon as you've clocked up 5 years residence, before you've been granted pre-settled status and including a time of pre-settled status. So apply as soon as you've got that 5 year residence. Don't leave it until the very end of your pre-settled status visa, because if you leave things very close to deadlines, the chances are you might miss the deadline. Now, it says there at the end, you may lose your pre-settled status if you commit a criminal offence, and this applies for settled status as well. Criminal offending will affect your immigration status. How it affects it depends when you receive that criminal sentence. So for sentences that occurred before the end of this year, it's assessed under EU rules. EU rules basically say it's really hard to ask someone to leave the UK based on criminal offending, because there are high thresholds that are required, and it needs to be very serious offending that may trigger the UK government saying you need to now leave the UK. And even if it's very serious offending, it also needs to take into account your life circumstances, how long you've been resident in the UK, because your length of residence increases the protections available to you. It also has to take into account your family members and how it will impact them if you're required to leave the UK. So offending before the end of this year makes it very difficult, in essence, for the Home Office to take your pre-settled or settled status away from you. However, offending from the 1st of January next year is going to be assessed under UK immigration rules. That basically means the thresholds are much lower. The Home Office can apply to take your pre-settled or settled status away from you based on very minor offences, and even not offences themselves. It could be just conduct or associations with people who they consider bad, and that may be enough for them to write to you and say, we're considering taking pre-settled status away from you. You need to write back to us and say why we shouldn't do that. And if we do that, then you're going to have to appeal the decision. So the rough rule here is to be a good citizen from the 1st of January next year, because offending from the 1st of January next year can have a great impact on your status. If you happen to get into trouble, because it's not just about, a choice. Some people are unlucky in life and get a criminal offence and through no fault of their own. If anything like that occurs to you, then seek immigration advice, contact Settled, find someone who can help you talk through this and to try and preempt what the Home Office might do. Don't wait until the Home Office write to you and say, we're taking this away from you. If offending occurs, if something bad happens and it might have an effect on your pre-settled or settled status, seek advice. The earlier you seek advice, the greater the likelihood is that we can prevent something bad from happening. Now, settled status is that indefinite status, which means it doesn't expire, but you do need to keep that electronic status up to date. Indefinite does have some conditions attached to it. You can lose it if you're outside of the UK for a continuous 5-year period. So on 5 years and 1 day, your settled status is automatically expired. It disappears. If you then try to return back to the UK, you're going to be refused entry, at which point you're going to have to return back to wherever you came from, and you're going to have to reapply for entry into the UK. You may not be able to reacquire settled status, at which point you lose your visa status in the UK and you're going to have to think of other visas to apply for. For Swiss citizens, because the Swiss have their own negotiated agreement, that absence period is 4 years. 4 years and 1 day, settled status expires. The same rules on offending applies for settled status. So make sure you keep an eye on your actions from the 1st of January. Settled status continues to be a route to British citizenship. So once you acquire settled status, you can consider applying for British citizenship. You need to hold settled status for at least 1 year, unless you're married or in a civil partnership to someone who's British, at which point you can apply as soon as you get settled status. But there are other rules related to citizenship you need to make sure you comply with. I'm not going to talk about all of the rules for citizenship because there's a whole nother topic on its own. However, one rule you need to be aware of is one called lawful residence. For citizenship, there's a requirement called good character. For those who are becoming British, they need to demonstrate they are of good character and they have been for the 10 years predating the citizenship application. Good character includes residing under immigration laws, residing in the UK lawfully. So for a 10-year period predating your citizenship application, you need to demonstrate that you're lawfully resident in the UK, which means that you need to show them your settled status, because that can cover your period from your grant of settled status. But predating your settled status or pre-settled status, you're going to need to show them that you were exercising treaty rights as an EU citizen, so you are complying with the free movement laws. You need to show them if you any other immigration status or residence documents you've been issued in the past. You're going to need to show that you were lawfully resident for a whole period. So if you're applying for citizenship, seek advice first, read up first, because it's complex and you may be refused. If you're refused, you're going to lose the fees, but you won't lose your settled status. So the consequences for being refused citizenship are financial. You'll lose a lot of money. There may also be bans that are imposed on you if you apply and, for example, you've got criminal offending. The Home Office will tell you can no longer apply for citizenship, and you'll next be able to apply after this date. But it won't affect your settled status. You won't lose settled status if you refuse citizenship. So don't worry about that. Now, the benefits of the settlement scheme are varied, and I've touched on a few. If you are a person that can be eligible for and engage with the settlement scheme process, then it means you can ignore any other visas under the immigration system. You don't have to pay for visas. You don't have to pay for associated charges that come with different visas, like the immigration health surcharge. If you're students, you have access to home fees, subject to meeting the other criteria for accessing home fees. You can have student loans. You don't need to show like in other visas that you're only working for limited periods of time. For work visas, for example, you're stuck with the employer that you apply for the work visa for. With the EU settlement scheme process, you don't have any restrictions on the courses you can study. You don't have any restrictions on the jobs you can take. You can switch courses, you can switch jobs. You're free to exercise your life however you wish in the UK, subject to the rules I told you about criminal offending and absences. So the EU settlement scheme, once you get pre-settled settled status, you can undertake any activity you want in the UK. Under the other visas, under the rest of the immigration system, there are restrictions on what you can do while you're holding that visa. There are restrictions on who you can do that for while you're holding that visa. So if you can bring yourself within the settlement scheme process, then it's a good idea to do so. It's a much easier life for you going forward. I mean, I've touched on all of those already on the earlier slides. So again, like under the EU settlement scheme, you're free to undertake whatever activities you want while you're residing in the UK, subject to them being lawful activities, obviously. Because this is an application process, by definition, you could be refused pre-settled or settled status. Now, the number of refusals are low. The number of ineligible applications are slightly higher, but in terms of overall numbers, they're still very low. So, the majority of people applying through this process are being granted pre-settled or settled status. However, if you happen to be unlucky enough to be refused either pre-settled or settled status, you can challenge it. There's a number of options available to you. You can reapply to the scheme, and you can reapply as many times as you like, as long as you can do so before the 30th of June 2021. So if you receive a written refusal letter from the Home Office, look at what they've said. If it's something you can fix quite easily with a second application, then apply again so long as you've got time to do so before the 30th of June 2021. If you receive your decision after the 30th of June 2021, you can't reapply. You'll only be able to appeal or ask for an administrative review from the Home Office. And you'll only be able to appeal if you made your application after the 31st of January this year, because that's when appeal rights came into force in law in the UK. An administrative review is a review done internally by the Home Office. So appealing has greater options available to you with greater challengeability, but an appeal process is long and complex. If you end up having to challenge it through an appeal and administrative review, talk to someone who knows about this stuff before you do so, because those processes are complex. So engage with organisations like Settled if you need to do something like this. So on the deadline itself, I've stressed it a number of times, the 30th of June 2021 is the ultimate deadline. Please, please, please apply before this date. However, if you miss the deadline, you can apply late, but only if you've got good reason. If the Home Office accepts your good reason, they will process your application. If they don't accept your good reason, they're going to reject your application, and you're going to need to challenge them through the courts in order for them to consider your application again. So it's really important you apply before the deadline, because there's no guarantee you'll be permitted to apply late, even though you're allowed to apply late. And also, until such time you're granted a status under the scheme, you're going to have an interruption of your rights and entitlements. You're not going to be allowed to apply for new jobs. You may be dismissed from your current job. You'll be unlawfully resident in the UK until such time they grant you a status under the scheme. So it's really important you apply before the deadline. However, there are of December 2020. So this means if you're working in the UK or you're employed in the UK on the 31st of December this year, then you are a person who's exercising their free movement rights in the UK, which means if you apply to the EU settlement scheme and you don't get your status by the 30th of June 2021, then you will see no interruptions of your rights and entitlements. However, if you're not exercising your free movement rights in the UK by the 31st of December or on the 31st of December this year, and you apply late to the scheme and you don't get your pre-settled status before the 30th of June, you get it afterwards, then you may see an interruption in your rights and entitlements. And this is because only people who are lawfully residing in the UK on the 31st of December 2020 are protected beyond the 30th of June 2021 if they don't yet have their pre-settled or settled status. This is a very complex thing. It may change as time goes on, as we near the deadline. So I'm not going to touch on it too much now. I'm happy to answer questions on it afterwards. Bearing in mind that I've talked for quite a lot already, so I'm going to speed up even more quicker than I'm talking right now. Pre-settled status, I'm going to touch on a few points about this. When you're granted pre-settled status, it's because you're resident in the UK before 11 p.m. on the 31st of December 2020. To get pre-settled status, you only need to provide one document to show that you're resident in the UK before the 31st of December. So like a boarding card is enough. And it's only granted for people who are not continuously resident in the UK to get settled status. You can apply for pre-settled status when you're outside of the UK. So you can get it as long as you're still maintaining a continuous residence in the UK. So if you're outside, you can apply for pre-settled status while you're outside, as long as you maintain your continuous residence in the UK. But there are some of you who may be outside of the UK right now and you're breaking your continuous residence because maybe the length of residence is beyond 12 months or the important reason, or there's no important reason. If you think you've broken your continuous residence in the UK, you need to return to the UK before the end of this year to start a new continuous residence period. So once you start that new continuous residence period, then you're eligible to reapply for pre-settled status. And that protects you in the future. Then you can look to see whether you've really broken your continuous residence or not. But if you think you have, or you know you have, you need to return before the end of this year. You need to restart your residence in the UK afresh. You need to reapply for pre-settled status if you already got pre-settled status, or apply for it for the first time. And this is part of the reasons why I'm talking about this, is because there's some people outside of the UK due to the pandemic If you're outside of the UK due to the pandemic, that's fine. That should be considered an important reason, but it must be an important reason for your entire duration of absence, and you need to have evidence that you were locked out of the UK because of the virus. And if you're outside the UK for a second long period, and you already had one long period in your 5 years, well, then you've definitely broken your continuous residence, because you can only have one long period of absence. So if you've broken it, return before the end of this year, restart your residence, and then reapply for pre-settled status. Same principles apply here. If you think you've broken your continuous residence for whatever reason, you need to restart your residence in the UK, start a new continuous residence period, at which point you're eligible, re-eligible for pre-settled status. If you don't do this and you've broken your continuous residence, and you return to the UK after the end of this year, well, you're locked out of the EU settlement scheme. For those of you who do get pre-settled status, this question comes up a lot. On the letter that confirms your pre-settled status, it says that you can retain your pre-settled status if you're absent from the UK for up to 2 years. You can be absent for up to 2 years without losing your status. So you'll be able to return on your pre-settled status if you're outside of the UK for example, for 1 year and 6 months. However, you would broken your continuous residence in the course of doing that. So while you can retain your pre-settled status based on long absences up to 2 years, it will break your continuous residence, and you'll break the eligibility for settled status. So when you see that 2-year rule in your pre-settled status grant letter, please ignore it. It's going to be of no help to you. You'll be refused settled status later. Just ignore that rule. So some people have asked this question. I'm arriving very close to the deadline. Am I always eligible for pre-settled status? The Home Office have told us verbally that yes, it doesn't matter how long you've been in the UK before the 31st of December. It doesn't matter if you come in for 1 day and then leave again, you're eligible for pre-settled status. I would, however, exercise some caution, because they've only confirmed that verbally to us. They haven't given us written guidance on that. I would exercise caution about very brief entries into the UK and then leaving again and coming back after the 31st of December, thinking that you're eligible for pre-settled or settled status in the future, because I worry that in the future the Home Office may say that's not residence, that's visitation, at which point we're refusing you settled status. So try, if you're going to return or enter the UK before the end of this year, try to reside here for a good period of time, start building your life here before you start leaving again for holidays or to finish up any obligations you have elsewhere. Just exercise a bit of caution. At this point, I can sum up quite briefly. Remember, your pre-settled status doesn't automatically convert to settled status. When you're on pre-settled status and you want settled status, you have to reapply to the scheme. You have to fill in the form, you have to click submit, you have to do everything again to get settled status. Don't presume pre-settled turns to settled just by the act of residing in the UK. You need to actually apply for it again. So make sure before your pre-settled status expires, you reapply to the scheme for settled status. There's a lot of further information available to you. I've got lots of links on the slides and lots of information on there, but I'll make these slides available to you so you can go and access them afterwards, because I'm conscious that I'm very close to the hour mark, so I want to answer some questions. So thank you for listening, and if you don't have any questions and you found this useful and you know someone is European or a family member is European, please remind them they need to make this application. The more people we tell, the more chance we've got of making sure everyone applies before the deadline. So thank you very much.
Okay, thanks, Chris. Thank you. There were some questions, but honestly, you took all the time. No, I'm joking. There were some questions that were quite interesting in the chat, and Maria and I have answered to most of them, I hope. There was a question about family reunion for EU parents, but I would like you generally say something about family reunion and what is going to happen during the grace period. What is the grace period really? What is going to look like? Okay,
so parents, grandparents, and great-grandparents can join the EU citizen or the spouse or civil partner of the EU citizen at any time in the future. Okay, so this locks in family reunification rights for our elderly relatives. It allows us to look after them and care for them at the point in time when they require that care and help. So they don't need to rush here before the end of this year to join the EU citizen. And this is parents, great grandparents and great grandparents, if they're still around, of the spouse or civil partner, and also of the EU citizen. Currently, they can apply to enter the UK in a number of ways. If they're European, they can just enter the UK up until the end of this year. From the 1st of January onwards, if they want to enter and join the EU citizen in the UK under the scheme, they're going to have to apply for a family permit before they arrive in the UK. So they have to actually apply for permission before they can enter the UK under the EU settlement scheme. But once they're in, then they apply for pre-settled status. However, it doesn't allow all parents and grandparents to join EU citizens and a spouse and civil partner of the EU citizen. They need to be dependent parents. For applications up until the 30th of June 2021, the Home Office are going to assume dependency. That basically means the Home Office will accept by definition of their family relationship that they are dependent. So they won't ask for evidence of their dependency in the application. But if your parent or grandparent applies after the 30th of June next year, dependency is no longer going to be assumed. This means that in your application for a family permit, you're going to need to have to provide evidence of dependency on the EU citizen or the spouse or civil partner of the EU citizen. So if you want to join them, you need to show that you're dependent on them. You need to provide evidence of the financial dependency, the emotional dependency, the support that you're providing for them. So it's possible to join at any time in the future, but it only can be parents and grandparents who are dependent. So I hope that's covered that question.
Yes, and I think you have answered also a question that we just received about how do you evidence family members. So that one covers. Another point that has been raised a couple of times in the chat is you mentioned about people with permanent residence and indefinite leave to remain, ILR, and you said that those people may decide to apply or not to apply. And I think that you need really to clear what is permanent residence and ILR, and not confuse the two, and who can choose and who has to apply.
Yeah, look, if it's up to me and I'm going to give advice, I will say, unless you're British, apply. Just apply to the scheme. There are no disadvantages to applying to the scheme, and it's free. And if you can engage with it, do so. Because my worry is you may have an immigration status, but you're going to misunderstand what that immigration status means, and you may find yourself unlawfully resident in the UK because you made a mistake about what you actually hold. So there's two types of two types of permanent statuses we can talk about. One issued in the UK immigration law, one issued in European law. The ones issued in European law are not going to be valid in the future. You must apply for settled status if you have a document that says permanent residence and it's issued under EU law. That's the one that I said earlier that looks like a visa stamp on a blue card, and it says permanent residence document on it. If you've got a blue card that says permanent residence document in it, that's the EU version. It's not going to be valid in the future. You need to apply for settled status before the 30th of June 2021 deadline. However, if you've got anything else that says indefinite on it somewhere, that's issued by the Home Office, so a stamp in a passport, a letter that says Home Office in it and says you've got indefinite leave to enter, or you've got indefinite leave to remain, or you're free from immigration control, or anything that sounds like that, then you've got permanent status in UK immigration law, which means you're protected under UK immigration law and you have a choice to apply to the scheme or not. However, as I said, there's benefits to applying. Even if you've got that UK immigration status already, you can re-engage with the Home Office. You'll further protect your residence here. If you lose that piece of paper in the future, then it really doesn't matter. So really, if you're going to follow one piece of advice out of my answer, is just apply to the scheme. If you're not already British, apply to the scheme, just in case you don't understand the status you have and you make a mistake and then you find yourself with a lot of problems later on.
Thanks, Chris. We got an hand raised by Sabina. Sabina, if you want, you can unmute yourself.
Hi, thank you. Thank you, Christina. I have in mind a family whereby the mother is EU pre-settled with a child here. The father is non-EU and has never came to UK, but wishes to basically rejoin his family here once he sorted the issues there. It's just a question of how will that help? Because I know he can apply linked to her settled status, isn't it? He will help with the childcare until finding a job. But he needs to be here before the 31st, or he can sort out the issues and not rush.
So
I just want to give the right advice to the family.
Yeah, of course. I mean, it's the same concept that I answered in the earlier question, that family members of EU citizens and family members of the spouse or civil partner of the EU citizen don't have to rush to come to the UK before the end of this year. And there are specific family members this applies to. Grandchild, great-grandchild of the EU citizen or the spouse or the civil partner of the EU citizen, they can join any time in the future. So these are considered,
even if they hold a different citizenship.
Even if they hold a different citizenship, nationalities of family members are irrelevant. It's only that they meet that family relationship requirement, and they were that family member before the end of this year, and they continue to be that family member when they apply in 10, 15 years, 50 years time.
Great.
So in this case, the parent can come. They don't need to be here before the end of this year. They can apply when they're ready to do so.
Thank you very much, Christopher.
You're welcome. I think, Christina, you're on mute.
Sorry about that.
That's okay. We all do it.
Another question was about the validity of the ID documents and people without a physical documents. What will they have to do?
So validity of what, the digital document?
The passport and IDs, or if they don't have it at all.
Okay, so passport and national ID cards. The general rule of thumb is they need to be valid to apply to the scheme. However, if they've expired, you can rely on old passports and national ID cards, but only where you've got a valid reason why you can't renew it. So as I said before, like, I'm quite lazy when it comes to my personal documents, although I'm very strict about helping others. When it comes to my own documents, I'm quite lazy about it. I let things expire when it revolves to me. So sometimes I might be lazy and I might not renew documents. That's not a reasonable excuse to rely on an expired passport. For a reasonable excuse is it's too expensive to do so because it requires me and my family member to travel back to, Bulgaria, for example, because we can only apply from within Bulgaria. At which point, if you can't afford it, then that's a valid reason to rely on an expired document. However, there may also be people who don't have passports or national ID cards at all. You need to try, if you can, to apply for a passport or national ID card, and you need to try starting that process now, because embassies and consulates are inundated with work and the processing times are increasing day by day. If you can't get a passport or national ID card before the deadline, either because the embassy or consulate hasn't been able to issue you one, or because they have too much work, or they can't prove your nationality or identity, then you'll have to rely on other evidence to prove your European citizenship or your identity if you're a family member of a European citizen. The Home Office have a list of other documents they might consider. Their birth certificates, marriage certificates, family book, letters from local authorities, any letter that's issued by a government or an embassy or consulate. It's a weird list because if you have any of those, then the likelihood is that you could probably get a passport or national ID card. So if you don't have any of those, then your proving your identity and nationality will start becoming quite complex. At which point, if you know you're in one of those circumstances, contact Settled and see if they can start helping you, because your application will be very complex if you can't get a document and you also can't prove your identity and nationality in other ways. You're going to need to have expert assistance with your application. So contact the team at Settled very early and as soon as possible, so you can start working on that application, because it will be complex.
Thanks,
Okay.
Chris. And I think we got the last one, and it's just to clarify this. If an EU citizen has got a family member who is British, so for example, your spouse is a British, do you still have to apply?
So what, the EU citizen?
The EU citizen is
Okay.
married to a British.
All right,
So
okay.
many people think that
Yeah.
this is a protection.
Okay, let's put it this way. You know, any visa, and including citizenship, there are no benefits. There's no real benefits from being married to someone who's British. It doesn't give you like a special recognition. It doesn't give you special protection. You know, being married to someone who's British is not a special label that allows you to like circumvent some of these rules and protects your lawful residence in the UK. You need to be granted pre-settled or settled status unless you're already British. So really, like, engage with this scheme. Don't assume you're okay. If you're not sure, please don't, you know, just sit there and ignore it. If you're not sure, contact Settled, contact any other organization that provides free advice, and put these questions to them. Make sure you understand what your circumstances are, to make sure that you know whether you need to apply or not. But a rough rule of thumb is, if you're not British already, apply to the scheme. Like, there's no disadvantage from doing so. You're not going to be punished in any way. You're not going to lose any other rights and entitlements if you get pre-settled or settled status. So just apply to it to protect yourself.
There is a question,
yeah.
sorry, Christina, it's come a couple of times on the chat, so I was trying to explain, but I think it's easier that Chris explains.
Sure.
I think we have been asked, what is the difference between holding settled status and having British citizenship?
Okay, so settled status gives you quite a lot of protections. I know there's a lot of anxiety out there about settled status, and a lot of people are thinking that they need to apply for British citizenship because settled status is not secure. Well, settled status is like a different version of a status called indefinite leave to remain. Indefinite leave to remain has been around for decades. It's a very secure status. It's never been removed off of people because of political choices, because of political declarations, because of change of governments, because of trade decisions. Once you get settled status or indefinite leave to remain, your status is protected, and you need to do something yourself to risk losing it. So being absent for too long, or have something that affects your character or criminal records, at which point then a Home Office can look to try and remove it off of you if they can do so. So you can quite easily just stay on settled status if you don't want to apply for British citizenship, or British citizenship is too expensive for you to do so. However, citizenship gives some extra perks, let's call them that. If you're British, it gets a little bit harder for them to take citizenship away from you. It becomes a little bit harder for the Home Office to ask you to leave the UK. But it's not impossible to take citizenship away from someone. It's not impossible for the Home Office to take citizenship and then force someone to leave the UK. It can still be revoked because of conduct, criminal records, albeit much more serious offending. Citizenship also gives you an ability to vote in referendums if the UK ever decides to hold another referendum. And it allows you to vote in general elections. Citizenship gives you consulate assistance at British embassies and consulates abroad. Citizenship might be required for certain jobs. For example, jobs in the security sector may require you to be a British citizen to be able to apply for it. But those are the extra perks of citizenship. If none of those apply to you, then maybe you don't need to apply for citizenship. However, if the anxiety is still so much for you that you're still unsure about settled status, and you don't trust this lawyer that's just turned up today that you never heard of before, and you're just not sure about settled status, and no amount of like advice or reassurance is going to help you feel settled with settled status, then maybe that's an excuse enough to become British. But British citizenship really is a choice for each individual. You decide why it's important for you. You apply, and before you apply, make sure you understand the requirements. And if you need to get advice about it first, because it's an expensive process for one individual. If you're applying as a family, you're into the thousands of pounds at that point. And if you're refused, you'll lose a lot of money. So maybe paying for a little bit of advice before you apply might be financially prudent for you to make sure that you get your citizenship granted. Okay, thanks.
Okay, thanks. I think the very last one was about someone that would give his ID, so someone, an EU citizen living abroad, but without maybe proof of residence for the last 6 months, enough to apply for settled status based on historic residency. So they were saying, could the family members apply on the behalf of these absent EU citizen?
Okay, so if you're an EU citizen and you're outside of the UK now, and you've been outside of the UK for more than 6 months, well, it doesn't really matter. If you've got 5 years historic residence in the UK, then you rely when you're applying for settled status from outside of the UK, you're relying on that 5-year historic residence. So let's say, for example, you were in the UK 10 years ago and you left the UK 4 years ago. We've got 6 years of historic residence. You can apply for settled status, say where you are in France right now, and provide evidence of that historic residence in your application. What you need to do then is to show that you've not been absent from the UK for more than 5 years after that 5 years residence in the UK. So at which point you can use any evidence to show that you haven't been outside of the UK for 5 years after you've previously resided in the UK for 5 years, because that's the rule for acquiring settled status based on historic residence. Even if you're outside of the UK, you need to have 5 years residence in the UK and then not subsequently been outside of the UK for 5 years. So you could prove that by showing your travel records, you know, showing flight tickets back to the UK. You don't need to show your residence in the UK after you left. You just need to show that you haven't been outside of the UK for more than 5 years after you've got a historic 5 years residence. So you can use your flight tickets or hotel bookings, anything to show that you haven't been outside for 5 years. Put that in your application from where you're applying, and then you'll be granted settled status. We've done multiple applications like that, and they're granted very easily. So you won't have any problems with it.
Please, what about pre-settled status? If you're not present in the country, can you apply from abroad?
You can apply from abroad for pre-settled status, but only if you haven't broken your continuous residence in the UK. So this is where it gets a bit complicated for people who have been outside of the UK for a very long time now. You'll need to demonstrate, you know, that it's an absence of more than 6 months, but not less, more than 6 months, but not more than 12 months. And it's for an important reason, and you have evidence of that important reason. So you can apply for pre-settled status, but in that application that you're making from Hungary, you need to show that your absence is your continuous residence in the UK has not been broken. And if your absence is a particularly long one, you need to show an important reason with evidence of the important reason. So you can apply outside, but it's a bit more complex because of your absence. If it's too complex, or you've broken your continuous residence, return to the UK before the end of this year. If it's something you think you can apply for from outside of the UK, but you're just not sure, contact Settled, put the questions to them, and do so quickly, because it's the 9th of December now. If you have to return to the UK, you don't have much time to do it.
And just to clear what Chris has just said, I would like to share, I don't know, can you see my screen? Can you see how to calculate absence? This is something that many EU citizens follow through the gaps. They divide their period in 12 months. And they calculated the fact, for example, in this case, we got Francesca. She has done 2 months absence in the first year, or 3 months, sorry, 7, 8, and 12, and 4 months in the second year. But if you follow the Home Office way of thinking, she has already broken her continuous residence, because the Home Office can decide randomly, let's say, to calculate the 12 months. They don't follow a calendar year, they don't follow the day that you arrived or the day you have applied. So people have to be extremely careful on counting absences.
Yeah, and again, if you're not sure, contact Settled. Like it's really easy to break this, and it's not easy to fix once you've broken it. especially if you're broken it and it's beyond the 31st of December this year. So if you've got any questions about your particular circumstances, contact the team at Settled, give them all of the information, we'll be able to answer it, okay?
Okay, Chris, thank you very much. I think we've answered to most, I think all, I hope all the questions in the chat and the one that you raised now. But if you go any other questions, of course, you can contact us by email at advice@settled.org.uk, and we will come back to you with an answer. I would like to pass, well, I would like to thank Chris, first of all, sorry. And I would like to pass the forum to Maria and ask her to share her presentation. Chris, thank you very much.
You're very welcome. Thank you, Christina.
Maria, your microphone is muted.
Yes, I'm just trying to share my screen. Can you see my screen now?
Yes, you want to put it in PowerPoint presentation, maybe.
Yes. Okay, here we are. Right. Okay, so after after Chris's presentation regarding all the technical side of the or legal side of the EU settlement scheme, I'm going to talk to you with the help of Christina about how to help people on the ground and the things that you can do to help residents of Islington and the things you can't do. So I'm going to talk a little bit about giving immigration advice in the boundaries and the regulations. And after that, I'm also going to talk to you a little bit about vulnerable groups regarding the EU settlement scheme. Who are the people who might be vulnerable and what you can do to help them and how to identify them. So Christina has very kindly got some statistics from the borough of Islington. Would you like to go through those, Christina?
Yes, sorry. Well, we did a bit of research since we last spoke with Katie, and we looked at what are the services in Islington. Of course, at the moment, many are closed because of COVID-19, and some are online or through phone, emails. But the majority of people that we know, this is really not only vulnerable people. We talk about people maybe that just need some questions to be answered. So there are different needs. And we call the Citizens Advice Islington, and the drop-in services are closed. I was on the line. I rang 3 times. I was on the line for something like 30 minutes. And I couldn't get through anyone that could help me with my queries about the EU settlement scheme. I rang the Islington Law Centre, and I had an answer machine, and they rang me back. They told me that their services are oversubscribed. So they say, call us back and put your name in a waiting list. Then I rang the Arachne Greek Cypriot Society, and they told me that they didn't have anything for me until the new year. And finally, I contacted Inca UK, which wasn't in the list. The first, the Citizens by Islington, the Law Centre, and Arachne Greek are in the Islington Council website. But I did another research and I found that there is also Inca UK in Islington. So I rang them and they told me that they can help Italian people and family members of Italians, which is really good because I am Italian, but it wouldn't help the majority of EU citizens. So as you see, the situation in Islington is precarious. If you think that you are an EU citizens and a European that is listening to radio, TV, finds information that is not very reassuring. Although we say that the deal or no deal that Boris Johnson is discussing today with Ursula has nothing to do with the citizens' rights and the withdrawal agreement, there is a lot of insecurity. So we want to go through what you can do maybe to alleviate some of this insecurity and to help EU nationals and their family members in Islington. So Maria, I'll pass it to you now.
Yeah, I want to add a little bit to what Christina was saying. We had a stall, rather, and an event in Islington on the 1st of February this year, just shortly after Brexit Day and before the lockdown. And the profile of the people who came for Settle's help were mostly the elderly EU citizens. So we had a few Italians, we had quite a few Spaniards as well. So I think all in all, we helped around 15 to 20 people face to face on that day with the scanning facilities at Islington. So that would give you an idea of what, sort of demand in the demographics of the EU citizens. But obviously, we would go through all the vulnerability criteria and try to identify some more people who might need help. So what constitutes immigration advice? This is something very important to keep in mind because we would really like to help people, but we need to know what are the things we can do and what are the boundaries of advice. So the advice in the UK, immigration advice, is regulated by the 1999 Act, and it stipulates that there are two requirements for advice we give people to be classified as immigration advice. So the first piece of information is that it must be related to a particular individual, and it must concern a relevant matter. So if I phrase it generically saying, for example, EU citizens in the UK need to apply to the EU settlement scheme, that would be classified as a general statement, okay? But if I just go and tell Christina, you are an Italian citizen, you must do this application, it's very important that you do this. So that starts getting into the boundary of immigration advice. So when you tailor the advice to an individual, is when you start stepping in what can be considered immigration advice. So it's good if you are advising people to keep matters really generic. So try not to step and tackle people's circumstances. Just try to keep it generic or signpost them to resources or refer them to other organizations. So advice from family and friends is generally not considered strictly immigration advice because you have their best interest at heart. So even if you're giving them wrong information, this type of advice, it can be wrong, but, nobody's going to be prosecuted for doing this. But if you are in a capacity where you are advising a third party, then you need to be very careful with the things you say. Giving unregulated immigration advice is a criminal offense. So I just want to make you aware that unregulated immigration advice is rife. And there are a lot of EU citizens at the moment who are being offered services to apply for the EU settlement scheme. They can take the form perhaps of accountants or people who deal with their general affairs, and they are charging them to apply to the EU settlement scheme. So unless they are a lawyer and they're regulated, or unless they are registered with the OISC, we're going to see who the OISC is in a minute. So they shouldn't be charging people, and they shouldn't be really sort of advising them in their immigration matters. So who is the regulator? The regulator, or one of the regulators, there are different regulators, but immigration advisors are regulated by the Office of the Immigration Services Commissioner, and that is the OISC, and you can see their logo here. So that means that Settled is an organization that is registered with the OISC. So Settled has 100 volunteers and the members of staff, and we are, most of us, registered for the level 1 OISC accreditation limited to the EUSS. So that means that we can help people with general applications to the EU settlement scheme for them, for the family members, and we can help people with non-complex cases. If a case is complex, or if it has to do with confirming someone's British nationality, or helping people with criminality, we would have to refer it to a higher level. Although we have a level 2 advisor in Settle that is at the moment taking our complex cases. A registered organization can train its volunteers to inform citizens about their application to the scheme. So that's what Settle does. And well, advice at the level 1 limited to the EUSS must be mostly generic, as we said, and restricted to straightforward and non-complex cases. Right, so we just want to remind you that providing unregulated or poor immigration advice is illegal, as we said, and it can have very negative effects on the person. The potential implications can be catastrophic. So families can be separated, people can be removed from the country. The people can spend a lot of money trying to put right when they are given bad immigration advice. If they have to then go, get a legal representation to put it right. So we need to be very careful with this. It's a note of caution. Right. Now we're going to talk to you quickly about vulnerable citizen categories. So there is an organization called the Migration Observatory of Oxford, I think, and they have produced a couple of reports, but here we have the latest version, the 2020 report called Unsettled Status, which EU citizens are at risk of falling to secure their rights after Brexit. So they have done an analysis of what are the difficulties people are facing to apply to the scheme and what are the hurdles. Okay, so I would like to remind you that already there are around 4 million applications submitted to the scheme. As Chris was saying before, some of these people have been granted pre-settled status, and they still have to submit a further application down the line. Really, nobody knows how many EU citizens are there in the UK, but there are millions. So even if a small percentage of these EU citizens fail to submit successful applications, that can be a huge number of people. And whatever we saw with the Windrush generation scandal can happen again to EU citizens if they don't get the help they need and if they fail in this process. So the main difficulties people can have is not being aware of the scheme and not realizing they need to apply. So we had a question before about spouses of British citizens, for example. Sometimes they think, well, I'm married to a British citizen. We hear this a lot. We're married to a British citizen. Surely I'll be fine. That's not the case. You need to apply to the EU settlement scheme if you haven't got a previous UK immigration status. Also, long-term residents sometimes can get into trouble. I hear a lot of Spaniards, I'm Spanish myself, and people, well, I've been here, 30, 40 years, I don't need to do anything. So probably some of these people might already have a status, but as Chris was saying, if you don't have proof of the status, then, you need to apply to the scheme to be on the safe side. People socially vulnerable, which are, the usual vulnerability categories, victims of modern slavery, homeless people, etc. People with other barriers to navigating and understanding the system itself, which can be people who don't have a very good English level. They might not understand. The classical example is when you get indefinite leave to remain. That throws people back. Like, okay, I need to leave to remain. What is this? So the legal lingo and the complexities of understanding instructions of the process can be a little bit complicated for some people. Then people who cannot provide their identity, so they don't have a valid passport. Children sometimes are in this category, as sometimes they haven't got passports, they might have birth certificates, but they don't have passports yet. People who struggle to show evidence that they have been living in the UK. And the final hurdle people might face is people who forget to convert from pre-settled status to settled status within the 5 years of receiving a status through the EUSS. So we have actually individual cliff edges for a lot of people who have pre-settled status. If they forget to convert that into settled status in the future, they might, lose their rights. So here are more groups of people, so you can see exactly who these people are. So children in care and caregivers, victims of domestic abuse, people living in poverty, homeless people, migrant Roma communities, very short-term residents. So these are people who have arrived, close to the deadline. If they can't prove they're here before the end of the transition period, they might be in trouble. Children, if the parents don't apply, there are cases of children who haven't, their parents would forget probably to submit applications for them. People with past criminal convictions, or people who are in prison, people without a good social network, people who are really isolated, citizens born outside the EU. So you have certain communities of dual nationals. So you have all sorts of combinations of them. You can have, I don't know, Senegalese, French, Italian, Argentinian. So they hold EU passports, but they might have been born outside the EU. So these people might not realize they need to apply as well. The same thing goes for non-EU family members. Perhaps if they already hold a biometric residence card saying they're family members of EU citizens, they might not understand that they need to apply to the EU settlement scheme, because some of these biometric residence permits have validity till 2022, 2023. So they might think they're fine, but they still need to apply. People who are expecting to return home, people who think, oh, well, I'm not going to bother, I might not end up staying in the UK. What are you going to close the door to it? In this group, we also have students, EU students, university students, and EU students in general. And well, there's a long list of other difficulties and other, groups who might struggle to apply to the EU settlement scheme. So I would share these slides with you so you can keep all these things in mind. What happens if you need to help someone? So I think an important role of councils is to identify those who might need help to apply to the scheme. And, when you provide other services to people, you might get to know that they are EU citizens. So it might be an idea to remind them or signpost them to apply to the EU settlement scheme. So if people need help, this is something you can do. If they have a help regarding their application, so they want to know if they have uploaded the right documents, they want to know why they haven't heard from the Home Office yet, why they haven't received an answer to their status, and all sorts of practical questions. The first point of call is the EU Settlement Scheme Resolution Center line. And in general, the service is good. The advisors are quite polite, but at some point we have identified that they might, not give consistent advice, let's say. So there are a few pitfalls here and there with the advice they give. But if people have questions related to their applications in general and why they haven't received an answer, if they lost the original PDF, if they can upload more documentation apart from the 10 documents they are allowed to upload, you can signpost them to the Resolution Center. Then complex cases, which involve, as you can see, complicated situations, domestic violence, trafficking, people with no ID, with criminal records, and derivative rights of residents. When we talk about derivative rights of residents, we are talking about people who are, for example, a non-EU carer of EU child, or they are mainly carers of children or carers of adults who are vulnerable, and you know, it's a little bit complicated for them to apply to the EU settlement scheme. So there is an organization called Here for Good Law. We work very closely with them, and they are a charity of lawyers. So they are the people who take these very complex cases. As Christina was saying before, you know, people can go always to the CAB in general, and there are some CABs that have funding to help with the EU settlement scheme. Then local charities in your area, you can find in this website called EURights.uk. There is this website for the European delegation. If you put your postcode, it would tell you a series of services that are available near you. And you can always consult the list of Home Office funded organizations to find services near your area. So if you decide to signpost a person, well, we would advise you to try to frame it in a reassuring way. You know, don't scare them out and say, you know, because that might deter them to apply altogether if they feel they are going to be rejected. So we tend to reassure people and say, don't worry, we'll trying to find some help for you, and you're probably going to be okay. We just need to consult your case. You know, we're really kind and diplomatic about it, so we don't create unnecessary panic. These are some advice skills. Now working remotely, it's a little bit more complicated, but you know, obviously you need to guarantee people's confidentiality. So it's good to be in a quiet place. It's good to ask questions because people don't tend to give you all the facts. So it's good to know which dates they're talking about, what are the nationalities of the people involved, how long they have been resident in the UK. So that would help you gather information to be able to refer to the right service. Make notes of the key facts, because when you have to refer to another organization, it really helps if you can, when you're using a referral form, for example, if you were referring to settle, that you give us, you know, some information, some background information, so we know what is coming our way. You have to explain to the person what you're doing and make sure they consent with what you're going to do. For example, if you want to refer someone to settle, you know, they need to know you're referring to us, and they need to agree to it, that you are going to pass their information on to us, obviously for GDPR purposes and other purposes. You know, you need to ask for their consent in order to, unless you're asking them to contact us directly, then it's up to them to approach us. So we have covered this one. Yeah, when it's fresh, well, what we said before, while it's fresh in your mind, try to make a record of the advice you have given. Well, put it on the Settle app. That's more for our volunteers. So put it on the referral form if you are going to refer to us or to another organization. Okay, so now we have a few situations here, and I would like to tell you what would you do in each of these situations. So I don't know if you would like to unmute yourselves or you want to put it on the chat. It's up to you. So we have this situation. So a lady tells you she has been the victim of human trafficking and doesn't have identity documents. So what would you do in this case? Any volunteers?
Just to clarify the exercise, what do you think? Can you approach this person and offer advice, or you should contact another charity or an organization that deals with the complex cases, maybe? Does anyone wants to answer? You're all muted, by the way. Only a couple of people haven't got the microphone on. If you don't want to speak, you can use the chat.
Or we can go through the cases ourselves if you prefer.
Yes, we could.
You know, yeah. I'm a secondary school teacher. That's my background profession. So I'm I'm a big teacher. Yeah, I want to engage with my students. Anyway, so yeah, the complication here would be that this person doesn't have identity documents. Okay, so as Chris was saying before, it would be a bit complicated for her to apply to the EU settlement scheme. And then obviously there are a lot of safeguarding concerns. Being a victim of human trafficking, she needs help, definitely. So this one you would have to signpost to the relevant charities for the human trafficking and also for specialized immigration advice. They need to get a higher level of advice. Christine, I don't know if you want to go through the chat, if there are any interesting comments.
Yes, I will let you know. Yeah, at the moment there is someone that had a good guess, the wise guess of referring. Yes.
Okay, an non-EU citizen who wants to apply to the scheme and is a victim of domestic abuse, her partner must provide the evidence to support her application as her rights depend on his status. So this is similar to the one we had before. So this one needs referring as well. Oh, sorry, my phone is ringing. Let's do that. And yeah, just switch off my phone. Yeah.
Can I just ask something, if possible?
Yeah, go on.
I'm again a little bit confused. I mean, obviously, we'll be based on what everyone is doing here as a job description and where there are, I guess, limits. But in the two cases, for the first thing, what you should do is raising a safeguarding with the local authorities, because you have human trafficking, you have domestic violence.
Yes.
Yes, correct. Yeah.
Yeah, that's correct. Sorry.
I think one question from Sinead. Sorry if I don't pronounce the name correct. Ask if she does not mind if contact police to get supported before anything else. Yeah, that one is that case of human traffic requires special attention. We always say contact a specialist charity, and if you go on our website, there are the instructions on what to do. And we go several vulnerabilities, and for each vulnerability, we give advice on what people should do in these cases.
But what respects to the settlement scheme, after you follow all the right procedures, this person would need specialized help to apply to the EU settlement scheme. So someone wants to apply for the EU settlement scheme, but when prompted says he or she had a criminal conviction in his country and was arrested for an offense in the UK too. So this would be another case that you will have to refer. I mean, the main thing to keep in mind here is to tell the person that whatever they do, they really need to be clear about their criminal history when they do their application. So they shouldn't try to lie to the Home Office. So when they do say they have a criminal record, another set of questions open up in the application. So in order to declare this criminality properly, they would need the help of someone probably to make sure that they do it properly. And it can be a little bit complex perhaps. So a young person wants to apply to the scheme but has an expired passport. This is an easy one.
Can I, while we do that, can I just say that in the guidelines offered by the Home Office, and we are expecting some new guidelines soon, there are 6 countries plus France, and these countries, Spain, for example, is one of those, allow to use ID passports or ID documents, either passport or ID cards, that they are not valid anymore. But this is only for the application purposes. It's not for traveling. And there is a list of this country. I know that Italy, for example, will be added soon. So we are waiting for the new guidelines to come.
Yeah, you would. You should be able to refer this person to their local consulate or embassy. You know, this is a useful thing to do, you know, because it can be addressed. They can just apply for a new passport if it's not inside these regulations that Christina has talked about, because this is quite restrictive. It only covers a few nationalities, and the expired documents have to have expired quite recently, perhaps in the last year or in the last 6 months, but there are people who have expired passports for longer. So, but you would be able to advise this person, say, well, you need, you know, this is a generic statement, you really need a valid identity document to apply to the scheme. So try to go yourself, get yourself a passport. And if there is any reason why, any impediment why they can't go and renew the passport, they could ask for a paper application to the Home Office to prove their identity in an alternative way, but they might need help for that. So the easiest thing to do is to try to go to their you know, consular services and renew the passport. Then
can I just add something that maybe can come useful? If you receive a written confirmation after you've done what Maria said, so you go to the consular or the embassy and ask for a renewal, and you are told that there is a waiting of 4 months, so they wouldn't be able to apply then because there is something that is blocking them to make a quick application. Then you can use this letter or email to ask the Home Office. You can call the Home Office the Resolution Center, but you can ask them to provide you a paper application and help them to make an application without the valid ID. But they need to see written confirmation from their embassies or consulate that the ID cannot be renewed in a I would say reasonable time.
yeah, then we have a person who has been in the UK over 5 years and has applied, but the Home Office is granting them pre-settled status as the government databases don't hold enough evidence. So as Chris was saying before, when you apply and you have a national insurance number, that is not compulsory. So for those who are recent arrivals that haven't been able to get national insurance numbers, they can still apply to the scheme. But what can happen to these people is that the automated checks that the app does with the government databases cannot find information. So they get a message when they apply saying, we do not have enough information of your residence in the UK. So some people provide very limited information. They don't provide information for 5 years of residence. So they have accepted pre-settled status instead when they have been residing in the UK for more than 5 years. So it's very important that people try to submit an application for settled status. It's the way of making it, of addressing the situation more effectively is, you know, as soon as they notice this, and if they have more than 5 years of residence, they can submit an application for settled status and try to gather evidence for 5 years of residence and submit this with their application to make sure they get the right status. It can really make a difference to people to have a settled status if they are entitled to have settled status. It's a more secure status. You were going to say something, Christina?
Yeah, I was just saying from experience, we're currently helping Reading Council to make application for homeless. And I found helping people who work for Reading Council that their approach was, oh, as long as they get a status, that would have been okay. And although I agree that people need to have a status, my point of view is that really, if you know that if the person comes to you saying, I've been here for 9 years, which was the last person that I helped, you make every possible effort to help this person to acquire settled status, because it's the golden status. This person will not need to apply a second time. It's true that just a letter of the council saying the social workers say, I've been known this person for a week, will be enough for the Home Office to grant pre-settled status. But by doing so, you are making this person vulnerable to the fact that in 5 years' time they have to make a second application. They might forget, they might not have a valid documents at that time. So you're putting them under the stress of something else coming in 5 years' time. If that person deserves settle status, you really should help as much as possible to help them to achieve that.
Right. So we accept referrals. So if you wanted to refer to us, we have a referral form that I think we are going to email you. When we email you the presentations, we'll email you as well a referral form for Settle. So we keep a case log of the people we advise. It's a requirement of the OISC. So whenever we get a case referred to us, so we would keep it in our some data in the database, you know, at least their name and the date we received the case, in case we need to justify the advice we have given as we are regulated. And this information will be handled by us according to GDPR regulations. So this will be made clear by the organization that is referring to us, and it will be made clear to the person once we receive the referral and we engage with them. And well, I think that's the end for us. So if you have any questions, we still have a few minutes if you want to ask us any questions by the chat, or if you want to unmute yourselves.
Shall we stop sharing the PowerPoint?
Yes.
Just one thing to add. When we receive referrals, we're happy to receive referrals from local authorities if these are few. Like with Reading Council, we have established a partnership, and they give us a donation for the help that we give to them. Because it was a large number of homeless that we have been helping, and we're still helping with. So we're helping to give you support advice if it's a limited number, and we'll do it for free. But if we're talking about a large number of applications, then please consider the fact that we are here to help the most vulnerable, but local authorities have their own fundings and their own resources as well. Any questions? You're all muted, I think. So if you want to ask a question, we're fine. The session was supposed to finish at 3:55, but we're happy to stay another few minutes if you want, 10 minutes.
I just wanted to thank you
Asha.
guys.
Oh, sorry, but there is the Asha. Did you raise your hands?
Yeah. It was just a quick question. I think Christopher might have actually answered it, but it was just what if a resident misses that 2021 deadline? Really, what support will they get to, or what are the chances of actually getting some kind of status?
I don't know if Chris is still on the call, but if not, we can answer.
We can answer, yes.
Yeah, the short answer is that I mean, officially, if they miss a deadline, they would be unlawfully resident in the UK, right? Yeah. But I think the Home Office is about to issue some guidelines. They still haven't issued them about late applications. So at that point, we would get to know what are the consequences of late applications. So probably they're gonna take into account the person's circumstances and very critical cases. You know, if it was a very elderly person in a care home, or if it was a child in care, you know, certain categories might be covered. But we don't know what's going to happen to people who simply forget to do it or miss the deadline. You know, we don't know what the line is going to be. Probably not so flexible.
Because I wonder, where is the deadline? Where is that being publicized? Because I think I've just kind of heard the deadline through this training.
It's on the gov.uk website.
Gov.uk. So I think people who it will affect will probably know that they should be doing this.
Well, the problem with vulnerable people, if they are vulnerable by definition, they don't know really. They don't know. Okay. I mean, it's shocking to think that senior citizens, maybe they know, but they don't believe that this is an application made for them. They think it's just for new EU citizens. It's just younger people.
I think the home office communications are being quite limited. I think I heard a few ads on the radio, and before there used to be a few ads with a little cup of tea, but they were not forceful enough. It was, oh, are you an EU citizen? You can apply to the EU settlement scheme. You know, it doesn't really talk about deadlines.
Exactly. Yeah, that's what. Yeah, there wasn't a lot of pressure put on people. It was like a choice almost, but it seems like people need to get a wriggle on.
Yeah, I think the fact that we are under a pandemic, the COVID-19 hasn't helped at all, because the services that were available, like the check-in points, the Islington City Council, Islington Council has closed it, and that would have helped so many people. The libraries are closed, and those would have helped many people.
Can I just quickly ask, how difficult are those forms? How difficult is an application form? And do you need specific experience to complete one for somebody?
No, not really. Not really. Okay. It's difficult for people, for applicants themselves. If they are vulnerable, they might struggle to follow the application on their own. But if you, as we said before, remember, you have to be careful in terms of giving immigration advice. But if you are just a helper who just wants to go with them through the steps and the process without, giving them any advice on their situation, you just have to follow the steps that are to scanning the passport. Sometimes can be a little bit, you have to try a few times. So if it doesn't scan in the first instance, it has its little quirks here and there that you have to know, but otherwise it's relatively straightforward.
Right. The first thing, Kasia, when you say about the online form, the application is divided in two parts, as Chris was saying. And the first part, if you go a biometric ID, you do it with the app, EU Exit ID check. It's an app that you can download on your Android or on your iPhone if they are the latest models, and they go near field communication, which is the tool that lets you use card readers or QR codes. So if you're, again, a senior, maybe you don't have the right phone, and then it becomes more difficult because you can access the systems through this part of the application, and you have to post your card to the Home Office, your document, your ID document to the Home Office. And for example, homeless, they don't like it, from the experience that we have, they don't like to separate themselves from their ID cards, because they may not be able to go to an hostel, or they find it, they don't like to send ID documents to the homeless generally. There was another question before Asha, and was just an overlapping. And sorry if I saw Basia, you switched your microphone on, but there was somewhere else. I don't know if you got another question for us. No. But okay. So it's nearly time. I really hope that you found these couple of hours useful for you. We are really, really here to help you. And we are delighted that the Islington Council has asked us to present this scheme to you. We would like to thank again Kathy and Chris and everyone who has taken part to this training, because I think it's really the first step to help EU citizens, not just in Islington, of course, but in the UK, especially now that we work online. Katie, I don't know if you want to say something.
Yeah, it was just to say thank you very much, Christina, Maria, and Chris, for the presentation. It was really informative. And if you signed up via me, I'll have your email address so I can send out the PowerPoint presentation. But if not, I'll put my email in the chat so you can just let me know that you would like it, and I can forward it on.
Okay, so just to say, I'm closing the recording, but I'm going to send you all the recording and our presentation, Katie. I'm going to send you that, and then Maria maybe can add up with some more information and something else that maybe find it useful, like our referral form as well. Okay, thank you very much.
Thank you.